Well, hey, ladies and gentlemen, it's me, Jermaine West, and I'm back with the simple truth. I have a really special news update for you about the NDAA, the National Defense Authorization Act. I had spoke about it and did a simple truth news report on it a few months back, but I came across some articles that were very important that I wanted to share with you about this law, the NDAA. Well, what has seemed to have happened is, as I'm going through my different news sources, I came across a new news source, which is called naturalnews.com, and two articles specifically that relate to the NDAA. I want to share with you, give you a little update, and let you know what's going on from a simple truth perspective. You have to understand that this National Defense Authorization Act has caused many of people to become outraged at the belief that their constitutional rights would be violated by such a law. And what is starting to happen is that you have some on one side of the aisle and some on the other side of the aisle that are beginning to kind of clash about the different jurisdictional issues with this NDAA, and then the authoritative reasonings behind why a person could be detained. So let me get into the articles. The first article is entitled Constitutional Victory. Controversial NDAA provisions blocked, at least temporarily, by a federal judge. The article is Natural News. In a rare display of constitutional patriotism by a government authority, an Obama-appointed federal judge has put an indefinite block on the erroneous National Defense Authorization Act, NDAA. According to Bloomberg, U.S. District Judge Catherine Forrest of Manhattan, New York, ruled in favor of plaintiffs who earlier had sued the Obama administration over the bill's unconstitutional arrest and detainment provisions, which provide no protection for American citizens. The loosely worded Section 1021 of the bill cunningly grants the president unrestricted authority to use military force in detaining practically anyone for any suspected terrorist-related activity without warrant and without a trial. This section, which was the primary focus of the lawsuit, admittedly provides no protection for American citizens and is patently unconstitutional no matter how you look at it. The statute at issue places the public at undue risk of having their speech chilled for the purported protection from Al-Qaeda, the Taliban, and associated forces, i.e., foreign terrorist organizations, said Forrest in her opinion. The vagueness of Section 1021 does not allow the average citizen or even the government itself to understand with the type of definiteness to which our citizens are entitled or what conduct comes within the scope. Unless the U.S. Congress amends the bill to protect Americans against having their constitutional rights abolished in the name of national security, NDAA will remain blocked, at least formally. However, NDAA is just really an extension of the horrific U.S. Patriot Act, which was the Bush administration's precursor to NDAA that was passed immediately after the 9/11 terrorist attack. Now, ladies and gentlemen, as you can see from this article, I will leave links to this article so you can read it for yourself. But it is, how can I say this? It is being put in wording that makes it seem as if a certain group of the powers to be are looking to protect us as American citizens. Really? Now, here's another article that was on the same page, and it says, The title is Obama Administration Appears to Have Fully Intended to Use NDAA Against American Citizens. What? Our government doing something against us? Is that at all possible? Let's read. Speaking on the details of how the case has proceeded thus far, Judge Forrest explained that Obama attorneys made absolutely no attempt to defend the administration against the allegations. They also made no attempt to claim that the ambiguous provisions were intended only for foreign suspects, which in and of itself points to sinister intentions with the bill. The government was given a number of opportunities at the hearing and in its briefs to state unambiguously that the type of expressive and associational activities engaged in by the plaintiffs or others are not within Section 1021, said Judge Forrest. It did not. This court therefore must credit its chilling impact on the First Amendment rights as reasonable and real. Efforts to amend NDAA to specifically protect American citizens on U.S. soil from illegal arrest and detainment, however, have been met with resistance by neoconservatives such as Charles Cully Stimson, a former Bush administration official who is now Chief of Staff and Senior Legal Fellow at the Heritage Foundation. He and others claim that amending NDAA will somehow encourage more terrorists to come to the U.S. Really? These wildly absurd claims, however, were enough to convince the traitorous House of Representatives to recently vote down an amendment authorized by Reps. Justin Amish, a Republican from Michigan, and Adam Smith, a Democrat from Washington, that would have prohibited the detainment, capture, or arrest of any person in the U.S. under NDAA. According to the Daily Caller, the House rejected this amendment in an overwhelming vote of 238 to 182. The simple truth is, ladies and gentlemen, these new intrusive laws, bills, and authoritative injunctions upon the people of America just show you that it is not about having the people's interest in mind. It is about having the interest of the powers to be. Ladies and gentlemen, that is the simple truth. And as I always tell you, the simple things are oftentimes the most difficult to put into practice and to actually do. I want to thank you for joining me with this episode of The Simple Truth, and I'll be back with you with more updates to come.